Hi there. Welcome to today's presentation. Thanks for coming today. This is our second topic in our startup webinar series, which, before we've had one presentation, and now we're going to kick off our second one on key terms and entity documents. We also have in the series, we're going to have Series Seed financing term sheets. That's a three-part series we're going to add to this in coming months. And then we're also going to be looking at cap table basics and convertible notes in later presentations. But continuing on with this startup series, couple reminders here. This webinar is recorded, so if you have a chance to revisit the material if needed, we'll send a link out to everybody who joins today. And again, this is meant to be interactive by submitting questions. So if you have any questions along the way, please fire away through the chat feature. I'll be monitoring that, and I always forget if it's the chat feature or the Q&A, but one of them should work, and I'll be monitoring that, and so I can jump on and answer questions along the way. And just one other thing to note is that we have 30 minutes for this presentation, and it's key terms and entity documents, which is could take up a couple whole day presentations if we really wanted to get into the weeds on this. So I'm going to be making some generalizations, and we are going to be kind of narrowing the scope of what we're talking about, really just those major terms in entity documents, and really just to kind of give you a feel of what you should be thinking about when you're entering into your entity documents with other people. And so just that little disclaimer there. All right, so who's talking today? This is me. I'm Trevor Crow with Doida Crow Legal. We are as a firm, our deal is we help entrepreneurs grow, finance, and buy and sell businesses. And so that's our core focus. We help entrepreneurs solve complex business problems. And, we deal a lot with entity documents in doing that, whether it's a startup company starting an entity, it's a company that's been existing and needs to amend because they're adding a partner or another shareholder or doing an equity incentive plan, something like that. So we deal with entity documents day in and day out. It's one of the key practice areas that we deal with. And so that's just a little bit of background on our firm. But again, given the time, we're going to jump right into the material here pretty soon. This is me. Don't need to get into this, but been practicing for over 15 years, and really my practice areas are just what our firm does: M&A deals, private securities offerings, and then general corporate work, which is a lot of entity formations and commercial contracts. So that's me. Quick disclaimer, like any lawyer would have, this is an additional disclaimer basically saying that this presentation is meant for information purposes, and it's a complex topic that we're dealing with. But the right decision for any particular person is going to be vary greatly on whatever the facts of the circumstances of each person and their goals. So this really is just saying that not currently your lawyer. We can be if we enter into an engagement agreement, but this is really just is for informational purposes at this point. All right. So before we dive in, this is kind of a little recap of my last presentation, which was on choice of entity and the differences between an LLC and a corporation, what you might be thinking about when choosing an entity. And so I just want to just hit on that briefly, so we can kind of narrow ourselves on what we're talking about today. Main type of entities here, we have corporations, partnerships, LLCs, sole proprietorships. So there's a lot of different entities you can form under state law. And this is just kind of a quick list of it. There's others. There's cooperations, co-ops, and other sort of entities that you might enter into. Trusts can be treated like entities. So there's others, but these are the main type of entities that you might have heard of or might be thinking about when forming an entity. And so, the most likely choices when it comes to what we're dealing with, kind of small, medium-sized businesses, it really comes down to either C corporation, S corporation, or LLCs. Every now and then we'll have other entities like partnerships. For example, if it's a private equity fund or a venture capital fund or something like that we're dealing with, or if you have a certain ownership makeup, for example, if you have Canadian investors, we would have to form it as a partnership as opposed to an LLC if it was, in that situation. So there are certain reasons why we might go outside of this, but in general, most of the time when I'm forming an entity for an operating business, it's going to come down to either a C Corp, an S Corp, or an LLC. And remember, the C Corp, S Corp is really just a tax designation. So those are not, for state law purposes, you would just be forming a corporation. And then you would be making an election with the IRS to get the designation of either C or S corporation. By default, a corporation is going to be a C corporation unless you file the S election to be treated as an S corporation. All right. Then just a quick overview of the documents that we're talking about. You know, if you're forming a corporation versus an LLC, there's different documentation that you'll be putting together that govern those entities. For a corporation, you know, to form it, it's articles of incorporation or a certificate of incorporation, depends on the state that you're forming it in, on what it's going to be called. But that's going to be the main document that really, from the outset, forms it and brings it into existence. An EIN, that's just a federal ID number. Whoops, go back to here. That's just a federal ID number that you would have. And so that's typical for all entities to get that, and that helps you to form the bank account and things like that. Also in a corporation is typically bylaws. There also may be equity and IP documents. There might be a shareholder agreement, and you also may have a S election. And so those are the documents that may be involved in a corporation. For an LLC, you know, the similar document that puts this entity into existence is called something different for an LLC, usually called an Articles of Organization or a Certificate of Organization. Again, can vary by state law on what it's called, but that's the entity that's filed with the document that's filed with the Secretary of State, similar to the Articles of Incorporation, that puts this entity into existence. Again, you'd have an EIN, and then you would have what's called an operating agreement, typically, and the operating agreement is going to be an all-encompassing contract that's not filed with the Secretary of State, and that's going to allow you, go through all the different provisions of how the entity is run. So management provision, economics, all that would be built into the operating agreement. You may also have equity and IP documents, so documents where the members come in and invest. So it could be a subscription agreement, it could be a membership interest, purchase and sale agreement, and then also the IP documents are usually, if you have people coming in that are going to be working within the business that are getting equity, some of the founders, they usually are entering into IP documents that say, we're contributing all our intellectual property related to this entity, because oftentimes, founders get together and start talking about an idea or how they want to start a business. And that may happen before they ever file the Articles of Organization or the Articles of Incorporation. And so then you want to just make clear that anything that they've created prior to actually forming that entity is actually contributed into the entity and owned by the entity. And that's a key document that you might have. So that applies for whether it's a corporation or a LLC. And then lastly, I listed an S election. An LLC is a very flexible entity. You can file for an S election if you meet all the requirements of having, individual owners, under 100, one class of stock or one class of equity, those type things. Those if you meet all those requirements, you can still make an S election with an LLC. And so that's why the LLC is a very flexible entity. In a corporation, you will be, again, you can file an S election if you meet those requirements, but otherwise you're a C corporation for tax purposes. In an LLC, you're going to be, if you have more than one member, you're going to be taxed as a partnership for tax purposes, unless you make that S election. So that's kind of the distinction there. All right. So key concepts. These are really the key concepts that you want to be thinking about with any entity document. And this is just the broad provisions here, or the broad concepts, and then we'll kind of dig into each of them as we go through. But really, you want to think about how does management and control work? How does this entity work? Who can bind this entity, and what decisions can they make? What sort of voting is required to make certain decisions? All that, and so that's going to be built into the entity documents. And so when I put these in kind of buckets of things to think about, management and control is one of the big ones. Next is the economics. So you want to be thinking about how do the economics works, who gets what at the end of the day, or during the operation of the business. How do distributions work, or dividends if it's a corporation? How who is there classes of stock? Is there preferences, things like that? So it's the economics of the entity, how the money flows out to its owners. And then lastly, the other big thing to think about is transfer restrictions and buy-sell type provisions. So those deal with, can I sell my interest in this entity? Are there any restrictions on my ability to transfer those, to sell it to somebody else? Or are there buy-sell provisions, especially in closely held companies? Oftentimes it's a group of founders that start a business, and what they don't want is somebody to, say that they're going to be involved and get issued equity in that company, and then 10 days later decide they don't want to work in the company anymore, but they still own the equity in the company. That could create a problem for the other owners. They don't want to keep building this business with somebody who initially said they were going to be a part of the business and then aren't really participating. And so there might be buy-sell provisions in the entity documents to make sure that you avoid this free rider problem. So those are really the big three key concepts, I think, to have in your mind as we're going through, and we'll kind of separate those out and dig in a little deeper as we go through these slides. All right, so key terms. These are general terms. I added this slide. It's a little bit outside of those three big buckets, but these are just general terms, and I do see people mess these up from time to time or have questions about them. So I wanted to touch on these first. So first thing is the name of the entity. Sometimes with forming an entity with a Secretary of State does not have a system for I guess rejecting the filing of articles of organization or articles of incorporation. And so you may form an entity and forget to put in, one of these ending abbreviations here, like LLC or Inc. But those are typically required by state statute to have in your entity. And you want to have that in your entity name anyway, just because it shows the world that what you're dealing with when they're entering into contracts with this company or this entity, that they know that it has limited liability. And that's one of the biggest purposes for forming an entity, is to create that limited liability protection that you get. And so just a note on the name that if it's an LLC, you want to include LLC at the end, or limited. There's a number, it varies by state, but you can have other sort of endings in your name other than LLC. Like I said, there's limited or LTD. Those all work as well, but you want to have some sort of entity or some sort of ending in the name that shows that it's a limited liability company, or sorry, that it's an entity that has limited liability. And so for a corporation, it could be incorporated, it could be corporation, it could be Inc. So all those qualify as endings for your name, but you want to just make sure that when you're forming an entity, you have one of these endings in your name. Next is a registered agent. So in your articles of organization or articles of incorporation, all the states are going to require that you have a registered agent. And so one of the kind of deals with the ability to form an entity that has limited liability is they're requiring that you have this registered agent in the state and where you form it. So a registered agent is going to be there to receive service of process. So, if you form this, this entity is really just created by state statute. And so how does, if it commits something, or somebody wants to sue that entity, how would they do that? Because it really doesn't exist other than this filing with the state. And so the registered agent is there to accept service of process. And that would be, like I said, in the state and where it was formed. So, oftentimes companies are being formed in Delaware or other states, even though they don't have a presence in that state. And if that's the case, then you usually have to have a registered agent service that does have a presence in that state to act as your registered agent. And so there's a ton of companies out there that will that offer that service. But in general, a registered agent has to be if it's going to be an individual, it has to be somebody over 18 years of age. It has to be, if it's an entity, it has to be an entity that has a place of business in the state where you formed it. And typically it has to be a physical address. not a PO box. And so, the registered agent services out there, they will have a physical address for people to serve process on if that happens. And so that's what that's there for. Now, if you form an entity in a different state, so for example, if you had a company, we're based in Colorado. If we had a company that was a Colorado company that had their principal place of business in Colorado, but they formed a Delaware entity, then we're likely going to have to qualify in Colorado because we're also doing business in Colorado. So there might be other filings that you needed to have, but you would also have to have you'd be listing in your foreign filing your principal office and your registered agent in Colorado, for example, in that case. So there could be other filings, but you certainly have to have a registered agent in your articles of incorporation or articles of organization, and it has to meet these requirements. All right, so now let's get into the key terms. So, management, as I mentioned, that's a big one. Who can do what? And I've broken these out in an LLC versus a corporation. So in an LLC, one of the big ones is it can be set up as a manager managed or a member managed entity. And when you're a manager managed, it means that there's going to be some subset or of either the members or a third party that's going to be in control and have management authority to act on behalf of that company. Member managed means that all the members have management authority. Now this can be varied by the operating agreement on what sort of threshold of vote is required, or who has the ability to make certain decisions, which of the members. But in general, my comment on this is that probably 99% of the time, you want your entity to be manager managed. And that way you have the flexibility, because, if you set up an LLC and there's two members, maybe you want both of those members to have the managerial control. But that's fine. If you form a manager managed LLC, you can just have those two members appointed as the manager. But what happens if you add a member later that maybe is an investor that you don't want to have, the authority to bind the company to contracts and things like that, then now that you have these articles of organization that have been filed that talk about member management, and it gives this agency apparent authority that others may rely on and say, hey, I entered into a contract with this person who's a member, and your articles say, which is a public document, says that it's member managed. So I had the right to rely on that. And so again, while you may be able to adjust that in the operating agreement itself, the apparent authority that is given by having articles that talk about an entity being member managed, I think can sometimes be an issue. And so oftentimes, or a lot of times, we get clients that come in who've already formed their entity, because it is pretty simple to file the articles of organization. And they've, in Colorado, there's a click box on the articles that say it's either member managed or manager managed. And a lot of times they've clicked the member managed. And so if that's not how it's working in reality, for example, because there's only a few subset of the owners that are actually managing the company, then we have to file an amendment to change it to manager managed. But again, 99% of the time, I think the manager managed is going to offer you the flexibility to have different people managing the company, and so usually that's the right decision. Corporations are a little different. They have a statute. The corporation statutes really require that you have a board of directors, officers, and you have shareholders. So those are the three main components of a corporation as far as how authority works. And the shareholders, the way in just a broad generalization, is the shareholders appoint the board of directors, usually through a shareholder vote, and then the board appoints the officers, and the officers run the day-to-day operations of the business. So the board of directors is kind of there to review and vote on major decisions, things like, are we going to sell the company or not? And so that's where the board comes in, but that's really how the statute works. It's shareholders appoint the board appoints officers, and officers are kind of running the day-to-day operations. So that's the structure for a corporation. But a big thing, especially in closely held companies, is having protective provisions or different voting. And so you can modify a lot of these these voting decisions in either your operating agreement for an LLC or in, your a shareholder agreement or your articles of incorporation for a corporation. So you may have certain major decisions, and this is a good thing to think about when you're forming an entity is, for example, it's an LLC, you may have one person who's the main manager running the day-to-day business. But if you're a member of that LLC, there might be certain decisions that you want to require either a majority vote of the members or a supermajority vote. So you want to think about what those thresholds might be and what those voting provisions or what those decisions might entail that you want to make a major decision. So oftentimes this is built into the operating agreement, and it says, the manager can't make these certain decisions without a majority vote of the members or a supermajority vote of the members. And, those decisions can vary on entity, but, oftentimes that's sale of the company, entering into debt, issuing new membership interests, entering into affiliated party transactions, things like that, things where, you might want to have some more of a threshold vote rather than having the manager, especially if it's a sole manager, being able to make that decision unilaterally. In a corporation, you have to make sure you have these voting provisions built into certain voting provisions need to be built into your articles of incorporation. So for example, if you have classes of stock, you got to build that into your articles of incorporation from the beginning, or you have to amend your articles of incorporation to include that. So you may have the same sort of situation where you have either class voting, certain decisions are done made by a certain class of shareholders, or you may have a provisions in there that says you can't make these decisions, or the board and the officers can't make any of these certain decisions. Might be, again, sale of the company, taking on debt, issuing new interests or new shares, things like that, without either a vote of a majority of the shareholders or a vote of some certain class of shareholders. So those are also very important provisions to think through and make sure that, it's a kind of a balance, right? And it depends on what side of the table you're sitting on. If you're a minority investor into an entity, you might be, it's more in your interest to have these supermajority voting rights or the ability to require the board and officers to come to you for a shareholder vote on certain decisions. Whereas if you're the board or majority owners, you may want that to be something where it could be made, a decision made unilaterally. But it's always a balance between, efficient operation of the company, allowing the board and the officers to actually operate the company in due course without having to come to the shareholders for a vote, on every little decision, versus protecting, the minority shareholders from the majority shareholders and the board from making decisions that might not be in their best interests. All right. Fiduciary duties. So another key term in documents is what duties do either the manager in an LLC or the board and the officers have. Now in an LLC, there's a big, state law allows for freedom of contract, and so allows you to waive these. And so it's become fairly common to waive a lot of fiduciary duties, but this is certainly something to pay attention to. Now, if you're forming an entity and you're going to be the manager, then you may want to have these waived. If you're a minority investor into a entity, you want to take a real look at those provisions in the operating agreement to see what is being waived and what duties those managers actually owe to the company. For a corporation, oftentimes these are statutory, so you can't waive these fiduciary duties. These duties are by statute and by case law are required by the board and the officers of the company. And so then we go into this next bullet point on indemnification and exculpation. Now, in an LLC, again, you can waive duties, and you probably will also have a provision in there that says that the managers are indemnified by the company for acts that they take in their capacity as a manager. So, if I'm a manager of a company and I make a decision and I end up getting sued because of it, as long as it wasn't fraud or gross negligence or a breach of a duty, I should be indemnified by the company. And that's pretty typical, because you don't want to, expose yourself to personal liability for something that you're doing acting on behalf of a company. And so that's pretty typical in LLC agreements. But again, something to take a look at and to consider depending on what side of the table you're sitting. For a corporation, this is really, again, as I mentioned, because the fiduciary duties are statutory and case law driven. The company, often has a indemnification, either separate agreement or built into the articles that they're going to indemnify directors and officers, again, as long as they've complied with their duties and they haven't committed fraud or gross negligence in making decisions. So again, but those are really key provisions to take a look at and to consider when entering into entity documents. All right. Let's see here. Deadlocks. So, what are we going to do if there's a deadlock? You want to think through that. Is there going to be a member vote or some other way to break up a deadlock? This may happen if you have two managers that need to act unanimously to do anything. And so that could be a problem. In a corporation, oftentimes, things go to a vote and a vote of the board. And that's why we usually like to have a board that is made up of some odd number of board members. So if there's three, then you're either getting, two of the three are voting in one direction, and that carries the day. But if you do have an even number of board members, then you have the potential for a deadlock. So you have to figure out, well, what do we want to do in that situation? And then inspection of books and records. I added that in here. That's kind of a term that people, I think, kind of gloss over. But each entity, both corporations and LLCs, have statutory rights to inspection of books and records. You can build in additional rights, like require that the company provides quarterly financial statements or things like that. But usually there's statutory rights that are unwaivable in your entity documents. And so that's something to consider if you're forming an entity, that you can't keep, the financial records of the company, who owns the company, things like that, confidential from your other owners. The other members or shareholders of the company are going to have rights to those, and those rights going to vary by state law. But I did want to note that because that's something to consider. All right, economics. So now we're going quickly. Got to go quickly through these last few slides here, but economics, really, that's who gets what at the end of the day. Now, one thing to think about is capital contributions, especially in an LLC. You may have the ability for the company to call for capital contributions, or for the members to put more money in. And so you want to if you're investing in an entity or you're creating an entity, you want to determine what happens if the company needs more money. Are we going to issue new membership interests? Are we going to take on debt? Or are we going to be able to call for capital? In a corporation, usually there's no capital contributions per se in the entity documents, like the articles or the bylaws, but there may be a separate agreement, like a subscription agreement, if somebody has made a commitment to contribute additional capital in the future, or to buy additional shares in the future. That could be built into those documents. And then, what happens if somebody defaults on those capital contribution provisions? And so, again, in an LLC, there could be dilution penalties, or dilution. Just, we go out and raise the money from other people, and then your percentage interest in the company is diluted. There could be penalty dilution if you're really banking on those people making those contributions, or there could be a buy-sell trigger. And so those could apply in a corporation as well. All right, allocations. That's going to be for an LLC that's taxed as a partnership. You're going to allocate. It doesn't pay tax itself, so everything's allocated out. So it's something to think about, how that works, and it's got to have substantial economic effect. And that's really going to be, your accountants and attorneys that are dealing with that, but it's an important provision. And then in corporations, you got to remember that you don't, C corps, they don't allocate out because it pays taxes itself. But for an S corp, it has to be pro rata. Everything goes out pro rata based on your ownership of shares, and that goes to the one class of stock rule. So that's how that works. Distributions, again, this is the economics, and this is really set up however the deal is. So you could have classes of stock, you could have liquidation preferences, you could have, any sort of built-in preferences that one, class of stock or one certain group has over others, or it could all be common, right? So everything just goes out pro rata. So anyway, that's the real provisions that you want to think about when you're thinking about the economics. All right, transfer restrictions. We're running out of time here. I'm I'm going to go 2 minutes past, but vesting is a big one. So again, this helps with the free rider problem. If you want to have time-based vesting that says, founders that are coming together and getting shares as part of working for the company, if they leave early, then they don't vest in their shares and those shares go away. And that can help with the free rider problem. And that usually is not applicable to investors. So if you're putting in actual money in, then usually you don't have vesting because you've paid for those shares. Repurchase rights, there could be, again, repurchase rights that are triggering events based on termination of employment, death, disability, involuntary transfers. This would be a big one, again, for closely held companies where you want to make sure, whoever, who's in your company, who's the owner and who has rights to the company. So if somebody dies, maybe you don't want their spouse or their kids to own an interest. And so you might have repurchase rights built in. And that's another key provision that most closely held companies want to have. There could be other restrictions like securities law restrictions. If you invested in the company, you can't really buy those shares and then sell them to somebody else right away. Usually, there's a restriction that securities laws have. You may have other sort of transfer restrictions or buy-sell provisions like a right of first refusal or right of first offer. With two-person entities, you might have a shotgun buy-sell, which really just says one person names the price and the other person decides whether they're going to sell or buy. And so those are some of the typical transfer provisions or buy-sell provisions you might see in entity documents. And then some other ones to consider are co-sale or tag-along rights and then drag-along rights. I'll kind of talk about those in conjunction with each other. So the drag-along rights is really majority owners being able to force minority owners to sell. So if they say, a majority of the owners of a company want to sell and they want to sell in an equity sale. So, the buyer wants to buy all of the shares of the corporation, for example, the majority of the shareholders could force the minority shareholders to sell along with it because oftentimes that buyer doesn't want to buy just 80% of the company. They want to buy 100% of the company. And so the only way to get the deal done is to have these drag along rights that can force these minority shareholders to sell in that case. And then, the opposite side of that is these co-sale or tag along rights. You see those terms used almost synonymously, even though they are a little different. But really that allows the minority equity owners to sell along with certain other owners. So again, if maybe the founders or the majority owners want to sell, then the tag along rights would be the opposite of the drag along. That would say we can force you to sell our shares along with your shares to this to whoever's buying them. And so that's the opposite end there. And then preemptive rights are really just the equity owner's right to invest their pro rata share. So if the company goes out to raise more money, I can put in my pro rata amount so I don't get diluted by those new owners. So again, another provision to think about, whether you want to have it, it's really kind of a minority owner protection, but it might be something you want to have if you're trying to raise money. It kind of incentivizes investors, or certainly if you're kind of investing in an entity, it might be something that you want to have in there. All right. Well, that was a whirlwind tour here of major terms of investment documents, or I'm sorry, not investment documents, of entity documents. And so hopefully you took away some of the big provisions to consider. Obviously, we didn't have time to get into the weeds on all these provisions, but I think it's a good overview of the things you should be thinking about if you're forming an entity. So let me check if I have any questions. No questions now. So that's the second topic of our startup webinar series. We're going to get into series seed financing here next, and cap table basis and convertible note financing. So hopefully you can join us for those as well. Thanks a lot.